As we continue building on environmental risks such as water contamination and radon exposure, we now move into one of the most strictly regulated areas in real estate: LEED-based paint disclosures. Unlike many environmental issues that rely on general disclosure standards under AAC R4 281101, LEED-based paint is governed by specific federal law with clearly defined requirements, timelines, and penalties. This is where environmental awareness meets strict legal compliance and where mistakes can result in immediate and significant consequences. The foundation of lead-based paint regulation begins with the Residential Lead-Based Paint Hazard Reduction Act of 1992, commonly referred to as Title X. This law was enacted to address the widespread health risks associated with lead exposure, particularly in homes built prior to 1978. The law requires both sellers and real estate professionals to follow specific disclosure procedures before a buyer becomes obligated under a contract. This timing requirement is critical and often misunderstood, making it a common area of compliance failure. Under federal law, 42 U.S.C. Par 4852D, several key actions must occur before contract obligation. Sellers must provide the EPA-approved pamphlet, Protect Your Family. From LEED in your home, disclose any known LEED-based paint hazards, provide any available reports or records, and allow the buyer an opportunity, typically 10 days, to conduct a LEED risk assessment or inspection. If these steps are not completed prior to acceptance, the transaction may be subject to cancellation rights or legal liability. Arizona practice, through the AAR Residential Resale Real Estate Purchase Contract, has adapted to allow some flexibility while still maintaining compliance. In certain cases, disclosures may be delivered after contract acceptance, provided the buyer retains the right to review and potentially cancel the agreement. This approach, often referred to as the California Rule, has been acknowledged by HUD and the EPA as compliant when structured properly. However, this does not eliminate the agent's responsibility to ensure that disclosures are timely, accurate, and properly documented. Every contract involving target housing, pre-1978 property, must include specific language and documentation. This includes a LEED warning statement, seller disclosures of known hazards, disclosure of available reports, and acknowledgments signed by both buyer and seller. Additionally, brokers must confirm that they have informed the seller of their obligations and ensured compliance. Failure to properly include or execute these documents is not a minor oversight. It is a violation of federal law. Consider a real-world scenario. A listing agent fails to provide the LEED-based paint disclosure form prior to contract acceptance. The transaction proceeds, and the buyer later discovers deteriorating lead-based paint during renovations. The buyer files a complaint, and the agent argues that the issue was unintentional. Under federal enforcement guidelines, intent is not required. Violations can result in immediate civil penalties, and in some cases, criminal sanctions. The penalties for noncompliance are severe and designed to enforce strict adherence. According to EPA and HUD enforcement guidelines, there are no warning systems. Violations can result in immediate fines. Additionally, willful violations may lead to criminal penalties, including fines of up to $25,000 per day and potential imprisonment. This reinforces a critical takeaway. Compliance with lead-based paint laws is not optional and cannot be treated casually. It is also important to understand that not all properties are subject to these requirements. Exemptions include properties built after 1977, certain housing for the elderly or disabled, with no children under 6 residing, short-term leases, and specific transaction types such as foreclosure sales. However, agents should approach exemptions cautiously and verify applicability before assuming disclosure is not required. From a broker supervision standpoint, this section ties directly back to AAC R4 281103B, which requires brokers to implement systems ensuring compliance with applicable laws. This includes document tracking, training, and enforcement policies, such as progressive disciplinary procedures for missing disclosures. In today's regulatory environment, brokers are expected to prevent these violations, not simply react to them. As we prepare to move into the next section, we shift from regulatory compliance into broader environmental and structural concerns, including mold, geologic issues, and property condition risks. While lead-based paint is governed by strict federal law, other environmental hazards rely more heavily on professional judgment, inspection practices, and disclosure standards. This transition highlights the balance between black and white legal requirements and gray area risk management that defines modern real estate practice. Online discussion. Why is timing so critical in LEED-based paint disclosures? Answer. Federal law requires disclosures to be made before the buyer is obligated under contract. Failure to meet this timing requirement can result in legal liability, cancellation rights, and penalties. How does the California rule impact Arizona real estate transactions? Answer: it allows disclosures to be provided after contract acceptance if the buyer retains the right to review and cancel, ensuring compliance while accommodating practical transaction timelines. What is the broker's responsibility in ensuring compliance with lead-based paint laws? Answer: brokers must supervise transactions, implement compliance systems, and ensure that agents follow all disclosure requirements under federal law and AAC R428-1103B.